Here we go, rapid review. Time to get some knowledge. We're driving forward across enemy lines right now with contract formation, and we're gonna march courageously into the battle of the forms. Here we go.
Next big topic, we'll talk about formation of the contract, offer and acceptance and all that stuff. Some initial observations. Don't get freaked out by the battle of the forms, the great hard subject. You hear that and you shut down. Don't do that. Okay, it's we'll get there, but it's relax. A lot of it's more intuitive than you think. Contract formation under the UCC is largely logical and obeys broad principles that are easy to learn. There's some strange stuff, but it's actually pretty limited, like 22072. We'll get there. But here's a key thing at the outset. You don't want to jump to employing this strange stuff if you don't have to. So don't go there unless it's really called for. Think through the broad principles and the normal stuff first. Don't lose your head. Now, there's lots of ways to teach and learn formation under the UCC, such as by concentrating on the text of the statutory provisions. That's probably the best way. We're not going to do that because audio. So I'm going to do this mostly principles-based and try to concentrate on the logic of it. So here's broad principles, key points for formation. Remember, first, the UCC wants deals to happen. Next, the UCC sees a distinction between what sales executives and business people do, which is make deals, and what lawyers do, which is, at least according to the UCC, focus on legalese. So who do you think the UCC cares more about? The deal makers, because the UCC wants deals to happen. So the UCC almost has this attitude of, ew, yucky lawyers, even though it was written by lawyers. The UCC thinks deals can and should happen when the business people want to have a deal and when they think they have a deal, even if the lawyers would see differences. But the UCC also cares about freedom of contract. So if the deal makers want the legalese to matter, they can make it matter. Now, key thing to remember here is, this will help you with a lot of these formation problems, is that the UCC got rid of the common law's mirror image rule. Under the common law mirror image rule, you need the offer and the acceptance to be the exact same thing so that we have a meeting of the minds and we have a contract. The UCC got rid of that. Why? Because the UCC wants deals to happen. So it got rid of that so that more deals can happen. An effect of the common law mirror image rule is what people call the last shot rule, but it's probably better called the last shot effect, which is that if you're going to demand a mirror image between offer and acceptance, the last version of the contract that flies out there is a proposal, and then you have conduct. The courts are going to see that conduct as accepting the last version out there. So that's the last shot rule or last shot effect, and the UCC rejects that. So here's how the UCC imagines things. Some company makes instrument panels for huge machines with lots of dials and gauges on them and big red buttons. And if someone gets on the phone and says, "Can you send us 3 more X7000 instrument panels?" You bet. Deal, deal. Hang up the phone. All right? The UCC loves something like that. This is a deal and it's enforceable. The UCC is all over that because the UCC wants deals to happen. Common law of contracts would be freaking out. But the UCC is like, that's great, that's a deal, that's enforceable, we can do that. And the UCC will fill in the gaps and fill things in with defaults to make that an enforceable deal. So here's some ways that deals can happen. You can have one document that's signed by both parties. That's neat, that's tidy, that's a contract, and the terms are what's in the document. You can have a deal where there's 2 documents, offer and acceptance, and the terms match. That's great, that's a contract, and those are the terms. You can have an agreement reached orally, on the phone, or in person, and there are no writings. That's great, that's a deal, that's a contract, and those are the terms. You can have a written offer for purchase that is sent to a seller and it's accepted by shipment of the goods. That's a contract and the terms are the ones that are in the offer. Easy. Any written offer that's sent, if it's accepted by conduct, that's a contract and the terms are the ones in the offer. easy. Lots of easy situations here in formation that are completely logical. We don't need to lose our head, go off to some kind of battle of the forms. This is how most of the stuff probably works in the real world. Okay, here's something. There's a written offer for purchase that's sent off to a seller. An order acknowledgement is sent back by the seller to the buyer, but it has some differences in the writing from the offer. Now we have something that requires some more thought. So in the imagining of the UCC, and also in the real world, although less these days than back in a few decades ago when the UCC was put together, a lot of sales transactions would work like this. You'd have a document generated by the buyer that's a purchase order. And then it would be sent off to the seller, and the seller would generate a document called an order acknowledgement. And in lawyer words, the purchase order is the offer, and the order acknowledgement is the acceptance. Within these documents, the purchase order and the order acknowledgement, and if you've ever had a temp office job, especially if it was a few decades ago, you've probably seen a lot of these things. They kind of exist in two chunks. There's a top, easy to read part that talks about price and the item and the quantity. Those are what are called the dickered terms, when salespeople and buyers dicker back and forth and they reach a bargain. Those are the terms they care about. That's how they fill out the form. Then there's a bunch of boilerplate on the bottom that's the boring legalese that no one wants to read, the quote-unquote fine print. Now, most of law, we say, well, fine print, dickered terms, it's all the same, it's all law. But the UCC says, no, fine print's kind of stupid, so we're going to treat it differently. So you have to understand that to understand how the UCC goes to where it goes with this kind of weird stuff. So we have a purchase order or an offer that's been sent. It says one set of things, and then we have an acceptance, purported acceptance that comes back, an order acknowledgement. It has some different things. First, we have to determine whether or not the order acknowledgement counts as an acceptance. If we're going to have a contract, we have to have acceptance. So we ask, this is the language from the statute, is it a definite and seasonable expression of acceptance? Definite and seasonable expression of acceptance. If it doesn't count as a definite and seasonable expression of acceptance, then we don't have a contract. If it does, then it's a contract. Then we're going to have to figure out what the terms are, but we know that at least we have a contract. So let's talk about this. How can we determine whether or not this acceptance that comes back counts as a definite and seasonable expression of acceptance? It can still be an acceptance if the writings differ. We know that. That's the whole premise of this. But it's got to be close enough that it counts as an acceptance. So here's one way to think about it. It's not really an official test, but do the executives think they have a deal? Do the people without law degrees who are on the phone making the deals, do they think they have a deal? If they think they have a deal, then they probably have a deal, even if the lawyers would say, well, there's important differences here in the fine print. So if the executives think they have a deal, then as a rough approximation, then that's probably an acceptance. Okay, here's just some hypotheticals. Let's say the purchase order and the order acknowledgement have a different price. The purchase order is for 3 X7000 units at $10,000 each, and the order acknowledgement is, thank you, we'll fill that order for $50,000 each. There's no contract, okay? There's no deal there. All right, that's not a definite and seasonable. That's something the executives would think, oh, we don't have a deal. We're far apart on price. How about it's a different item? The purchase order is for an X7000, and the order acknowledgement is, we agree to fill your order for a Y17. That's no deal on that. Now, what if there's different wording on the remedies limitations? Okay, yeah, that's fine. That's still a deal. The sales executives didn't even read that stuff. We can still have a deal with that. Okay, how about the order acknowledgement adds some provision about how to send warranty notices? Oh, yeah, that's fine. UCC wants deals to happen. That's fine. We can have a deal with something like that. Okay, so now, and where's the dividing line in between? I don't know. Go ask your mom or dad. That's just something that we can have a big debate over, and you can look at a lot of cases and whatever. But the dividing line's somewhere in there. So we know that there's at least situations that will fall into those two different camps. Now, if we have different or additional terms in the offer and the acceptance, then we got to ask, okay, we know we have a contract, but what are the terms of the contract? We're going to have to figure that out. It depends under the UCC whether we have different terms or whether the acceptance has additional terms. And you could have a great philosophical battle about this, but we're not going to do that. We're going to keep going. We're not going to have philosophical discussions about it. But let's assume there's a difference between different or additional terms. If they are different, then the different terms knock each other out. And the terms are instead filled by the UCC with course of performance, course of dealing, usage of trade, UCC gap fillers, etc. So one offer has a choice of venue of the courts in Los Angeles County, and the acceptance has choice of venue of the courts in San Francisco. We'll fill it up with whatever the UCC will prescribe, and those things will knock each other out. This knockout rule is not actually in the UCC because they didn't think to put it in there, but it was created by courts in trying to figure out how to deal with the UCC, and the majority of courts follow this knockout rule, and it seems sensible. Okay, if the acceptance has an additional term, something thrown in there that wasn't spoken to in the offer, then the additional terms are considered proposals for adding to the deal. Okay, it's a proposal and it's just laying out there. Now, if the deal is not between merchants, then it just stays a proposal unless someone agrees to it. Oh, I was looking through the fine print and I saw you had this weird arbitration provision or choice venue, and I want you to know I agree to that. Oh, okay, well then now you have an acceptance on that. Otherwise it's just going to hang out there as a proposal. Now, if the deal is between merchants, there's merchants on both sides offering acceptance, then the UCC 2207 has these funny rules about automatically making those additional terms part of the deal unless some things happen. And this is where we get into some strange stuff. But you can see how far we are down here, that this is not all the deals. This is just comes up in this particular situation. We have additional terms where the offer and acceptance differ. We have still a contract, they're close enough we have a contract, but there's this additional term. So if it's between merchants on both sides, then the additional terms are automatically added unless they materially alter the deal. So a lot of ink has been spilled on what that might be, but you can just take a guess before you go into the case research. Or an objection is made within a reasonable time. Well, I know you're a merchant, I'm a merchant, and so I was reading this fine print because I know about 2207 too, and I don't agree to this choice of venue thing you stuck in here. Okay? Or the offer expressly limits acceptance to its terms. So if you send a purchase order that says, this purchase order is expressly limited to you agreeing to all these fine print terms and not adding anything, oh, then you can do that. I mean, if you want to be real particular about it, you can do that. In that case, an acceptance with anything different isn't going to add those terms. Now, what if both the purchase order and the order acknowledgement both say they are expressly conditioned on agreement to all the fine print terms and conditions? So they're both claiming this only counts if you agree to everything in here. Just take a second to think about that. Well, this is easy. Then there's no contract on the writings. Obviously, those writings can't establish a contract because they just said that they couldn't. Okay, so a contract might end up getting established by conduct. If the goods get shipped and the money changes hands, then we must have a contract, but it's not established by the writings. Okay, let's ask a different question. What if the purchase order and the order acknowledgement are contradictory in terms of the dickered terms, in terms of what the sales executives and the buyer executives care about? So one's ordering Y7000 and the other one's ordering an X1950. In that case, again, the writings don't establish a contract. Obviously they can't because they're too far apart. Now, a contract might end up getting established by conduct. We'll see, but the writings aren't establishing that. You know, it's the same answer to either of those things. If the writings aren't going to establish a contract, then we don't have a contract. So then, okay, now we have to figure out what are the terms if the writings don't establish a contract. And there's actually a very logical answer to that, and that's in 22073, and it says that the contract consists of all the terms of the writings on which the parties agree. So everywhere that the offer and the acceptance are the same, that's part of the contract. And everywhere where they're different, then we'll fill it up with the supplementary terms, course of performance, course of dealing, usage of trade, gap fillers. Make sense? So that's really essentially a knockout rule, except that one's actually written in the statute. That was it. That was Battle of the Forms. We did Battle of the Forms. It was less painful than you thought. I kind of snuck it up on you. That's the Battle of the Forms. Most of it's logical. There's that one part that's kind of weird about the additional terms, but most of it's pretty reasonable and not entirely counterintuitive.